to start. Oh, here we are.
Okay, then.
Hi.
See you later.
Okay, I'm going to mute our folks that just entered. All right, so hello and welcome to our webinar this afternoon. We are going to have a full house today, so I do encourage you, or ask you rather, to stay on mute. Those of you that are attending as a participant. Same is true for our presenters. If you're not presenting, we'll stay on mute. And in the meantime, if you have any questions, go ahead and put those in the chat box. I will note that we are both here on Zoom and on Facebook Live today, so that we can have as many folks participating with us as possible. So before we get started, if you could go ahead and drop in the chat box, let us know what you're up to. How are you continuing to create in this time? And without further ado, Louis Rickey, our Arts Commission Executive Director.
Thank you, Chapin. Over the last several weeks, we've had assessed that intellectual property issues and questions are really important to organizations and individual artists as they start to migrate content to an online environment to remain relevant and connected to audiences. And this is in two areas. One is protecting their own intellectual property as they do that, as well as considerations about using others' intellectual property as they do that. And to help us navigate these waters, we have a few guests with us today. First, Robert Midas, who is a partner of Midas, Gelberg and Rose, LLP, as well as Ann Aikman Scalise of counsel at Lewis, Roca, Roth, Gerber, and Christie. And finally, Scott Wiley, Interim Executive Director of Pro Bono Indiana. Scott is here to vet your questions that you'll be adding into our chat. And that's the way questions should come to our body here today. So we're very thankful for these folks lending us their professional expertise. And at this time, I want to turn it over to Robert Midas. Robert.
All right. So we practice entertainment and arts law in Indiana, which is a little bit unusual, but I graduated in 2000 after having been a musician, a professional musician off and on, and marrying Carrie Newcomer. Some of you might recognize that name, and a musician, a little bit more successful than me at making a living at music, but I became a lawyer and graduated in 2000 and decided that after a couple years in a big law firm of Baker and Daniels, it was called at the time, I would shift into this field. So now we're here 20 years later, believe it or not, and we represent largely musicians. And a shout out to the great John Prine, who was a client, and we lost last night, as you probably know, one of the greatest creative songwriters of the last 40, 50 years. But that's who we work for. We work for classical musicians to a certain degree, like Joshua Bell, a lot of rock musicians, folk, Americana, hip hop. We also represent authors from time to time, and represent filmmakers, and represent visual artists as well. And that is the world we live in. And it's all based around copyright. That is the fundamental basis of all creative arts, is copyright. So we want to spend time today going through Copyright Basics 101, and we want to answer some questions for you in the presentation, and then we will also take your specific questions following. So we're trying to get through the presentation so we can jump into questions as quickly as possible. Okay, how do I protect my creative work, especially online? That's really will be what Ann talks about more. That'll be registration and talking about copyright ownership. How do I avoid copyright infringement, especially online? I'll talk about that a little bit, and we'll answer specific questions you might have. And can I depend on fair use? Well, we'll see about that as we explain it. The subject matter of copyright is really all those things that you obviously would guess. Literary works, musical works and sound recordings. And I tell my students at the law school, unless you're a musician, that's the hardest thing to get in your brain, that there are two copyrights when you're talking music. Almost always is a sound recording of a composition. It could be a sound recording of birds, it could be a sound recording of a poem, but in the music world I work in, it's typically a song and a recording of that song. So there's Yesterday, written by Lennon McCartney, and then there's the recording of it by 1,000 different people since the Beatles recorded it in the 60s. Okay, different copyrights. Then there's dramatic works, plays and musicals. There's pictorial works, paintings. There's choreographic works, which are dance and put down into Labo notation. And there's audiovisual works. We also call those films and television. We watch them every day online, on Netflix, on Hulu. And now there's architectural works for the last 25 years or so. They added that classification. To have a copyright, copyright law only protects original works of authorship. Okay, so if it's not original or it's too simple to be considered original, just a squiggle, and there'll be no copyright that you'll obtain. And it must be fixed in a tangible medium of expression. So right now this is being fixed because I understand it's being recorded, but if it wasn't, if I was just standing in front of a classroom and I sang a song, you would have no copyright under US law. You might have state copyright, that's a different matter, but there's very little of that anymore. It's mostly preempted by the 1976 Copyright Act and all of the amendments that followed. Okay, it must be fixed permanently on your iPhone or on paper, in sheet music, or on a recording, etc. What is not protected? This is what we call the idea-expression dichotomy. What's not protected under copyright law or mere ideas. Once somebody came to me and asked me to represent them in suing somebody. We don't do a lot of litigation, but once in a while we'll jump into that. But she asked me if I could sue because she had created an idea about a TV show where people meet and get married at first sight. And I said, it sounds like an idea. I looked at it, I said, sounds like an idea, not so protectable. Well, she went and got another lawyer and filed a lawsuit, and it was thrown out of court. Because it was deemed, as you may know, there was a show similar to that. It was deemed to be copying of an idea, not specific, protectable, creative matter in the program. There was no dialogue, there were no specific characters, it was just an idea. So we can go through questions you may have about that, but basically facts and procedures and processes and systems and concepts and principles, and of course, inventions, which are the subject matter of patents, and trademarks, which are names and logos. Those are whole different areas of the law. But all those things like facts and procedures, you may think that copyright law protects them, and you would be wrong. It has to be creative material. We can answer more questions about that. So here you go. Here's two wizards, same actor. An idea of a wizard is not protected. So Gandalf and who's the other one? Dumbledore. The idea of a wizard is not protectable, but the specific characters in those literary and motion pictures may be. Okay, so once you have a copyright in a protectable creative idea and it's fixed in a tangible medium, you then have the exclusive right to reproduce your work that's under copyright. You have the exclusive right to distribute that work to others. You have the exclusive right to publicly perform your work, namely a song or a dance, something that can be performed. Hold off on the sound recording parenthetical for a minute. You have the exclusive right to publicly display your work, and you have the exclusive right to adapt or make derivative works. So let's go through those for a second, give you some examples. If I have a copyright in a sound recording, let's just use my wife, Carrie Newcomer, records a song called Gathering of Spirits. And she records that and she owns that recording, then you cannot make a CD of that or make vinyl of that or put it up online and distribute it through Spotify without getting her permission. Okay. Now there are some exceptions we'll talk about, fair use being the main one. But the base rule is only Carrie Newcomer as the copyright owner may authorize the reproduction of that. And we know what reproduction is. It's a pretty simple concept, making copies of a sound recording. If I'm an artist, a visual artist, and I have a painting, I own the right, basic right to reproduce that painting in books or in posters, etc. I also have the exclusive right to distribute, or Carrie has the exclusive right to distribute her sound recordings on CDs or distributed online through Apple Music or Spotify or Pandora, etc. She also has the exclusive right, if she wrote that song, to authorize the public performance of that song, okay? And public display for paintings and adaptation to adapt that song, for instance, into, use it as a beat for a rap song. She would have the right, or sync it for a television show or a commercial. She has exclusive right to tell others, no, you can't do that unless I give you permission. And if somebody does do that, that's what we call infringement. So let's go to the parenthetical for a second. If you are a musician and you want to talk about this more, you can ask questions about this, but there is no public performance right in sound recordings in this country. Uniquely in the United States, we never granted that because the radio stations had too much power. So in other countries, when you play a record, like a Beatles record on Apple or on EMI of She Loves You or Yellow Submarine, EMI and Apple would get paid and would be licensed, have to be licensed by the radio station. In this country, that was never the case until digital performances in the late 90s came around and they added it in, and that's what we call Sound Exchange, collects those royalties, disperses those royalties and grants those rights to digital radio. But we have no general public performance right in sound recordings. Everything else, plays, ballets, anything you can think of that you could perform other than sound recording, songs, that's what ASCAP and BMI and CSAC do. They collect public performance royalties for songs, but not sound recordings. It's a little bit complicated, I know, so ask me questions to follow up. Okay, so backing up, if you own a copyright, if you're an author or a publisher or a record company or an artist who owns their own copyrights, you get to control all those 5 uses of your copyrights, your materials. Okay, so Anne is going to take over in just a second. She's going to talk about registering your copyrights so that you can enforce your rights. And I think rather than going through this slide and then just having you repeat, Anne, I'm just actually going to skip this slide and let you talk about registration and protection of copyrights and finish on this last slide until you hand it back to me. This is duration. Once you create a work, after 1978, January 1st, the new act, as we call it, now it's 34 years old, right? So once this new act came into effect, everybody had life plus 50 years protection. Then they ramped it up around the 90s. I forget when, but it added on 20 years. So now it's life plus 70 years. So when you're deceased, you add on 70 years in time, and that is how long a copyright lasts. So it could be 100 plus years. If it's a work made for hire, for a corporation or for a company hires you to make it, then it's 95 years from publication or 120 years from creation, whichever is shorter. So that's about 100 years, give or take. So it's about a century. You know, if you live 30 years and you're in the first bullet point, and then it lasts 70 years, it's give or take, could be easily a century long. And there's a lot of people who feel like that's too long. and that's more of a policy question. I'm not sure we would need to discuss that today. I personally will throw out my 2 cents. If you can build skyscrapers and put in your hard sweat to build that and own it forever, and your family owns it until you sell it and reap the benefits, I think creative artists like yourselves and like my wife and my clients really deserve a century worth, their families deserve a century worth of income from their exclusive rights and copyright. So that's my 2 cents. I'm going to now hand it over to Anne, and I'm going to try to unshare this. Okay, Anne, you want to come on?
Yeah, she'll be able to take this sharing over. Perfect.
Great. Well, thank you very much, Robert. Appreciate that overview. And I am with Louis Roca Rothgerber Christie out in beautiful Tucson, Arizona. But I'm originally from Indiana. I'm a Hoosier. I'm an IU Law School grad. And I do practice in the area of trademark and copyright. I'm not admitted in Indiana, so I can't really serve clients in Indiana, but Louis graciously asked me to assist with this presentation, and I'm happy to give you some of the formalities, as Robert mentioned. So let's talk about U.S. federal copyright registration. We're going to provide an overview of copyright filing forms and links to additional information and resources on copyright issues. And just as a reminder, a few principles to keep in mind, and Robert went over these, but it's good to repeat them. Copyright exists from the moment of creation. This is, subsequent to the 76 Act and subsequent to 1989. We own that creative material the moment it is fixed in a tangible medium of expression. So Robert went over very carefully the fact that ideas cannot be protected by copyright. It is important that you file for federal registration within 3 months of publication of your copyrighted material. And the word publication does not mean the same thing under the Act as it does in the publishing industry. You think of a book, you think of the fact that if you get a publisher and the book is published, then you have publication. But under the copyright law, publication has to do with when you share your work with the public. So it is a broader definition. What you want to do is file for copyright registration within 3 months of sharing your copyrighted material with the public, because you preserve important remedies like attorney's fees and statutory damages. And these, when you're trying to enforce your copyright, become extremely important. The other side is faced with possibly having to pay your legal fees. They much more quickly comply. So filing on the federal level is electronic and is fairly inexpensive. There are a range of fees. There is a range of fees, and these are specified at the copyright.gov link that I'm going to share with you later. Usually you're talking about $45 or $65, depending upon whether it's a work for hire. It's going to be a somewhat greater fee. I think a group of photos is $55. Importantly, if you decide to file on paper rather than filing electronically, your fee will be at $125. So you want to file electronically and set up an account at copyright.gov. If you have to sue someone for infringing your copyright or get a lawyer and send a cease and desist letter, you will need a federal registration. It normally will take several months to get that. If you do have to enforce after filing and you need to shore up that registration sooner, you can pay an expedited fee for registration, which I think is in the $800 range, somewhere around there. And you can get that registration issued more quickly if you have a good reason for doing so, such as enforcement. And because of the international treaty known as the Berne Convention, a US registration protects your work in 178 member countries worldwide. So it's well worth the filing for many reasons. I'm going to go through some of the basic filing forms, and I probably will not click through at this time because we do want to get to our questions, but your links are provided and you'll get PDFs, I gather, after this presentation. Form TX is for literary works. You use it for published or unpublished non-dramatic literary works. So just want to explain that if you've written a screenplay, that's not Form TX. We'll get to that form later. This is for non-dramatic literary works. It cannot be used to register a collection of 2 or more unpublished works. The deposit requirements are 1 copy for unpublished works, which you upload, electronically to the Copyright Office. Or if the work is published, they need to have 2 copies of the best edition of a published work. So for example, we're doing a copyright registration for a children's book right now. And so because it's published, I had to ask for them to send us 2 of the actual books that have been published, and those will be forwarded to the Copyright Office. So let's talk a bit about authorship. The author, in terms of the forms that you're filling out, is if it's not a work for hire, it's the person who actually created the work, okay? If it's a work for hire, the author of the work is actually the employer, or in some cases, commissioned work may qualify as a work for hire. An employee acting in the scope of his or her employment, that means the author is not you. But if you're acting outside of the scope of your employment, then it's highly likely that if you're acting outside the scope of your employment, or you're an independent contractor, that you are actually the author and owner of the copyright, and the company or the employer would need to get an assignment of that copyright. Sometimes employment documents override these considerations and say that you on demand have to immediately assign the work to them. But keep an eye out for that as you're filling out forms as to who is the author. Works of the visual arts, those are filed on Form VA. So you use the form for pictorial, graphic, sculptural works, 2- and 3-dimensional works of fine graphic and applied art, and also for photographs, prints, and art reproductions, and maps, globes, charts, technical diagrams, and models. The deposit requirements are essentially the same as the literary. The form cannot be used to register a collection, and to register multiple works, for example, a portfolio of photographs, you need to use a different online application. And I'll show you where at copyright.gov that you can see how these forms shake out. I think I might be able to click through to give you an idea as you're learning how to approach this whole topic of copyright registration. You want to go to copyright.gov. I would like to point out to you this section called Law and Guidance, which hopefully you can see on your screen in my slides. And underneath it, you see the copyright law, regulations, rulemakings, compendium. All of those can get a little bit complicated. So I think, the most helpful ones are the forms and the circulars. And those, if you want to self-help, there's a lot of information under forms and circulars. So let me see if I can get back out of here. This Form VA cannot be used to register an architectural work. So you want to see Circular 41 under the circulars. Okay, next, performing arts. That use this for works of performing arts, whether prepared for the purpose of being performed directly before an audience, for example, plays, or indirectly by means of any device or process. So Robert was referring earlier to, film and television shows. The process of filming or recording, in any way, and Form PA will apply for dramatic works, for example, screenplay, motion pictures and other audio visual works, pantomimes and choreographic works, musical works, including any accompanying lyrics, which Robert, I'm sure, will talk more about later because he's the music expert. cannot be used to register a collection, but deposit requirements pretty much the same, and the PA form available at that particular link. Then on to sound recordings, Form SR. Use it for sound recordings, works that result from the fixation of musical, spoken, or other sounds other than recordings which are part of an audio-visual work as a whole. So here we're talking about a separate sound recording, not a performance, for example, a Form PA work that has music in it, but rather for a sound recording which is separate from an audio-visual work. And it can be used where the same copyright holder is seeking protection for the underlying musical, dramatic, or literary work contained in the sound recording. And I think, earlier Robert was talking about songs, wanting to, if you want to protect a song as well as the recording and distinguishing between the two. So deposit requirements for an unpublished work: 1, complete phonorecord or recording. Published work: 2, recordings of the best edition together with any printed or other visually perceptible material that is published with the recordings. And the form is available there. I'm sure Robert will have more to say about music, particularly in the Q&A session. Finally, one basic form would be for periodicals, single serials, Form SE. And you use this for each individual issue of a serial. For example, a magazine. It includes newspapers, annuals, society proceedings, periodicals. And don't use Form SE to register individual contributions to a serial publication. So if you write a magazine article, this is not the appropriate form, but maybe you should use Form TX for that as a literary work. There are some complex ownership issues related to periodicals. If an organization directed, controlled, and supervised the creation of the serial issue as a whole, then that organization checks the box collective work. And the term collective work means that the author is responsible for compilation and editorial revision, and may also be responsible for certain individual contributions to the serial issue. And there's link to the form. Finally, I want to comment on a couple of statutes that protect artists' rights that are not copyright statutes per se. These statutes deal with additional rights that have been conferred upon artists as a result of a separate statutory scheme. And the first that I wanted to mention, just so that you're aware of it, and this is not a detailed presentation on that because that's outside the scope, but there's the Visual Artists' Rights Act, which many of you visual artists may already be aware of, and it grants certain moral rights to visual artists. And among these rights is the right to prevent modifications that are harmful to the artist's reputation, and the right to prevent destruction of works that have achieved a certain recognized stature. A particular area of protection under the VARA is in relation to buildings. And if you're painting a mural or adding something that is incorporated into a building, there are specific provisions in VARA that cover that. And there needs to be a signed writing between you and whoever you're, or if you represent the building, you need a signed writing with the artist. And the remedies for violation of VARA can be either actual damages and lost profits or statutory damages. There are enhanced damages for willful violations. I wanted to mention very quickly a very notable case that's recent in the Second Circuit, I think it is, for an aerosol art case in Queens, New York. And this building that you see in the picture for many, many years was managed by an individual artist as the curator in a selection process where he reviewed various, what we might refer to as graffiti artists, but referred to in the case as aerosol artists. And he would give permission once he reviewed the proposed art for the artist to paint on this side of the building at this location in Queens called 5 Points. And over the years, he acted as curator of this side of the building of over 10,000 works of art. Then an owner of the building decided that he wanted to turn it into luxury apartments. And in spite of the temporary restraining order, he had all that artwork whitewashed. And he actually did that even against advice of counsel, which is amazing. But ultimately, a verdict was rendered for a willful violation of VARA in relation to 45 of the 49 works were found to have recognized stature, and there was a verdict of $6.75 million as that was payable. It may be on appeal again, but it's just worth noting. So just keep in mind, Visual Artists' Rights Act exists. Another act that exists that may be relevant to some with Native American heritage, Indian Arts and Crafts Act. It's primarily a truth in advertising law and allows purchasers to make a claim in relation to Indian-made goods, because if they are not in fact Indian-made, then there would be an action. It's actually actionable by the Indian tribes, individual Indians, or Indian arts and crafts organizations, and they can enforce those rights through a civil suit. Any award of damages that goes back to the plaintiff, and if it's an organization that sues, is minus the cost and the fee. So I'll give an example. If you say, well, this is, Navajo jewelry, it has to be Navajo jewelry, really, and made or licensed or endorsed, by the tribe. Some of you may know about a case that occurred in New Mexico in relation to, I think it was Urban Outfitters, and among the many claims, including trademark infringement, et cetera, was the Indian Arts and Crafts Act in relation to calling certain clothing that was being sold by Urban Outfitters, Navajo clothing. So just be aware that this exists. The United States also can enforce the Indian Arts and Crafts Act through criminal prosecution. Criminal penalties include up to a $250,000 fine and 5 years in prison. And I will then give the screen back to Robert to finish, and we'll take questions after that. Thank you.
Okay. I am coming back on here. You guys, let's see if we can. Okay. Get it full screen now. Does that work? Okay. So what happens when you infringe? That's one of the scariest things if you're a creative type and you're using somebody else's work and you're thinking it's fair use. We're going to talk about fair use in a second, but you get a cease and desist letter, or even worse, a lawsuit. What is infringement? It's when somebody owns a valid copyright, and we talked about that, and it has to be registered, as Anne described, and somebody has made an unauthorized use of that. The whole measure of infringement hinges on this idea of substantial similarity. And I put up the blurred lines cover here just to indicate one of the more famous cases in the music industry in the past several years, where a Marvin Gaye song was held to have been infringed by Robin Thicke and Pharrell's song Blurred Lines. And a lot of us copyright attorneys are worried about that because we thought basic ideas and mode of production was copied, but not actual melodies and chords and protectable content. A lot of people had took offense at that holding of that jury, but it was just one case, and it does let you understand that in every case where one work of art is being compared to another work of art, in this case a song, it measures substantial similarity with regard to that artwork. So in the art of music, it has to do with melodies, and you get musicologists to give what is called expert testimony, extrinsic evidence. And you also have the jury doing intrinsic analysis, just do they think it sounds like it was ripped off? It's kind of a scary concept if you get a jury that doesn't really like a defendant, which was this was the case. Pharrell and Robin Thicke didn't do very well in their depositions, didn't come across very well, and boom, it's $6 or $7 million infringement holding. But if it's art, you look at something else. If it's literature, you look at themes and characters and dialogue. So it's whatever the art is you're comparing and asking the question, is it substantially similar to the underlying work? What are the remedies if you were to get sued or you were to sue somebody? You could get an injunction. You would enjoin them from distribution of more CDs with that song or from streaming that song. You could impound those goods. You could get attorney's fees and statutory damages and costs if it was infringed after the registration occurred. That's why it's so important, as Ann mentioned, that you register it quickly upon publication. If you would ever want to enforce it, it would need to have been registered before the infringement. You do get 3 months leeway after you were to publicly sell your work. And if somebody infringed in that 90 days, as long as you're registered, or actually as long as you're applied for registration by the 90th day, you're okay. What are actual damages versus statutory damages? Well, statutory, it's court-ordered damages. You convince a judge or a jury that it didn't actually make that much money, the infringing recording or painting or what have you, but it was willful, it was bad activity on the infringer's part, and we want to slam you with $30,000 or up to $150,000. And if you don't have statutory damages issued, then you have to prove what actual damages were, how much money was made or how much money you lost. Okay, we can talk more about that if you have questions. What are exceptions to needing permission? Well, if something's in the public domain, then you don't need permission to use it. If it's in the public domain, sometimes it's hard to know if it's in the public domain. Before I think it's 28, it was 1923, but it's moving ahead every year now because of the calculation. But let's say before 1928, everything would be in the public domain. But after that, it really depends. And you need to do copyright searching, and it depends whether it was renewed or published with proper notice. It's very complicated. Talk to a copyright lawyer if you have any question about that. But older stuff in the 1800s, if it was published or written, then it probably is in the public domain without a doubt. And you can use it freely. How about permissions and licenses? Well, if you get those, then you can use something, but it depends what it says in the contract. Okay, we'll talk about that in a second. What about Section 110, a specific part of the Copyright Act, which includes the Teach Act? That's an exception we'll talk about, in fair use. Okay, public domain, it can either be, well, I've already talked about that. I'm going to skip over this slide. So permission and licenses. Could be exclusive, it could be non-exclusive, it could be implied, it could be a Creative Commons license, it could be a click wrap. You click it on a Getty Images on a website. You have to know what it says in your license. What does it say in the contract? If it's Creative Commons, be very careful, because we had a case where we defended somebody who used a Willie Nelson photograph, and they hadn't given proper credit to the photographer, or allegedly, and they were sued anyways, even though it was a Creative Commons free license. And some people are out there setting you up for infringement by saying you can use this under the Creative Commons license, but only if you do X, Y, and Z, including proper credit. So you have to be very cautious when you get download photographs from Getty Images or stock photo sites. You have to read very carefully what you're allowed to use them for, because they could be non-exclusive licenses only for online website use. And you go and use it on a CD cover or on a book cover, and that wasn't part of the license you were granted. Go back to the slide that says infringement, because that's what they could sue you for at that point. Teach Act and Section 110. You'll be given, I believe, copies of our PDF, and I'll let you work through that. But basically, if you're in person teaching students, you can perform or display certain works. If you're online, Section 2 allows you to do it for e-learning purposes online, but you cannot use commercial e-learning materials and get around any license costs by just saying Teach Act. It's very specific what it allows you to do, and you cannot circumvent commercial rights. It requires supervision of the instructor. It has to be part of mediated instructional online activities. You need to look into that and make sure you comply, that it's technically limited so the whole world can't get hold of the materials. And you cannot interfere with copyright restrictions, and you must have policies promoting compliance. We can talk more about that. What about fair use? I'm going a little bit quick because I want to just answer your questions here after this slide. Fair use looks first at the purpose and character of the use. And if you were asking if something is fair use, unfortunately, you would never really know the answer to that until a court decides it after you were sued. It's called an affirmative defense. So oftentimes people come to us and say, do you think this is fair use? As an attorney, we can give an opinion, which we're not giving today on this session, no legal opinions. But if you came to me and paid me, I might say I could grant you a fair use opinion letter, draft that for you for your documentary film. And we would go through it carefully. And then what we would normally do is provide this letter so they can go get insurance. If you're a creative filmmaker, you'll know what I'm talking about. It's called E&O insurance. But you could also get it if you're a songwriter or a record company, a visual artist, perhaps. I've never heard of that, but you could, if you're using, inspirations to create your works, you might think about that. You get errors and omissions insurance, E&O insurance, and usually they will only grant that if an attorney has reviewed the work. So we look at these things like a court, a judge or a jury would look at in determining whether the defense stands, and they would say, what is the purpose of your use? If it's non-commercial, you're better off. It's not definitive. None of these 4 points I'm going to discuss are definitive, but it's a balance test. So you would say, is it commercial or non-commercial? Commercial hurts your case, non-commercial helps. Is it transformative? Are you creating a new work, or are you just doing what Napster did and throwing it up on the internet, the same exact recordings? If it's transformative, it helps your case. So that's prong number 1 and the 2 sub-prongs. What is the nature of the copyrighted work? If it is the Beatles' Yesterday, a very highly creative song, and you're using that, doesn't really help your case. But if you're using a news story from the front page of the Indianapolis Star that says so-and-so was killed in an automobile crash today on I-70, yes, there's a little bit of copyright. We call it a thin copyright in that news story, but it's highly factual. So if you're using something where the nature of the copyrighted work is a slender, slim copyright, it helps your case. If you're using a highly creative painting or song, then that hurts your case. Is it published or unpublished? I won't go into that. I'll go to the next one. How much of it are you using? Amount. Are you using 90% of it, 100% of it like Napster? Or are you using only a sliver of it in your painting to create a new work, or just a slight 3 notes of a song? The less, the better for you to make the fair use defense. And finally, are you hurting the market for the underlying work? Did I really hurt the market for that news story in the Indianapolis Star? Probably not. Highly factual. But am I hurting the recording that I'm ripping onto a computer and allowing people to download for free anywhere in the universe? Yes, you're hurting the market for those sound recordings. You're using all of the work. They're highly protected work, and it's commercial use. That's Napster 20 years ago, almost to the day. I remember they were held in California to have infringed all those sound recordings. That's the perfect case to prove the opposite of fair use, okay? Because everything, they lost on every fair use prong. All right, so that's what I've got as far as the overview of copyright, plus what Anne contributed. And I think now we're gonna hand it over to Scott to take some questions, and maybe he's even accumulated some. So I'll take my slides off of share.
Great. Thank you so much, Robert. And I did accumulate quite a few really interesting questions, some really fun ones too, that I think will be informative for our folks. On behalf of all of us at the Indiana Arts Commission, for those of you who are arts nonprofits or individual artists yourself, these types of webinars, I will tell you, while Robert and Ann both indicated they were not making any legal opinions today, I am going to make one legal opinion, and that you were very lucky to have access to two of the most highly skilled folks in this area to provide this information in this type of venue. This is just gold in terms of helping us all protect our work and make sure we don't abuse anyone else's work. And both sides of that are so important, especially to our arts nonprofits here in Indiana and across the country. So a few questions, and I'll let you, if you want to unmute, and I'll let you and Robert fight over who answers each of these. So whoever jumps in first, but this is my favorite one. I just picked it first. It wasn't in that order, but it was one of those kind of old legal wives' tales. Like if I live with someone for 20 years, are they my common law wife? It's one of these. Here's the question. Is a poor man's quote unquote copyright worth anything, such as sending a song through the mail to themselves with a postmark date?
And I feel like I could answer this easily by saying no. Well, it's not worth much. It's worth 25 cents. It is worth just a tiny bit because you could go to a court and show your evidence that you created the work. It would be laborious. It would be hard to prove. It would be better than nothing. But I'll give it's worth a quarter. It's not worth much. Spend the $55 to $65, depending if you really think it's worth protecting, and file a federal copyright application. Right, Ann?
Absolutely agree. It's so easy now. Create your account at copyright.gov, upload the work electronically, pay $45 if it's your own individual work and there are no other copyright claimants. And that is, you know, the smart person's copyright. So that's the way to go.
Yeah. And by the way, this will rarely happen when you get three attorneys who all agree at the same time. And I'm going to have you follow up with this because it kind of follows along the same thing. You mentioned in your piece, and Robert just mentioned again, the importance of registration of your copyrighted work. We had one of the folks ask, is it possible, even if you miss the 90-day, the 3-month, is it possible to still register it after that 3-month period? And does that have any effect, or is it helpful?
Yes, it's definitely possible, and yes, you should do it. And it does have effect, and it would be necessary to enforce in court your copyright. In most courts, some courts give a little bit of leeway if you've already filed your claim, but you definitely want to pursue that copyright registration, even if you are beyond the period that preserves the extra rights.
So, yeah, let me jump in. People get confused about this. It absolutely doesn't matter if you register it before that 90-day period if the infringement hasn't occurred yet. You could register it 3 years, 10 years later. And if the infringement occurs 11 years later, you're good. You're just in the same position you would have been if you registered it within that 90 days. The only thing that 90 days does is it gives you 90 days to register it regardless of when the infringement occurred within that 90 days. So if you finish your work, publish it, and it's infringed immediately on the first day it goes up on Amazon, and then you register it, it's really, I said, apply for the registration because your registration date dates to the date they receive it in the Copyright Office. So if you register it 2.5 months later, you're still in the same position. You've been given a 3-month leeway. But if you wait 10 years to register it and it hasn't been infringed yet, go and register it because it could be infringed on the 11th year, you know?
Yeah, that's a good point. And I think that, Robert, one thing that we have arising frequently is that people don't consider registration until after they've become, you know, aware of an infringement, and that's a little problematic. So given that the cost of registration is so low, you know, we're always talking with folks about, get it registered before you publish it is the best, or
Yeah.
within 3 months.
One other quick point. I had the pleasure, I say with a little bit of sarcasm, of defending 3, maybe going on 4 individuals who have been sued by, many of you will know this name, Richard Leibowitz, on behalf of photographers. And while Richard Leibowitz is, if you don't know him, he's one of the most well-known plaintiff's attorneys for photographers ever to live. He's filed over 3,000 lawsuits, including during the coronavirus period here. The courts are just throwing up their hands. He's filed, I think, dozens, if not 100. Every suit that was filed in New York or in March was in intellectual property was his, except for one other. Everybody stood down and waited this out. What he does is he helps photographers go out and search electronically and register. And often what we'll see is that he's been sanctioned several times in the New York courts. He's called a troll, but he will stand up for artist rights. And we can talk about this if you have questions. But the issue is that when it's not registered at the time of the infringement and you try and defend against that and say, all you're gonna get from us is actual damages. It's worth, like a license fee of $300. Why would you sue? Here's the answer, and then I'll end this little diatribe here. Here's the problem, that he will make sure it costs you in legal fees tens of thousands of dollars, if not $100,000 from your insurance company, so that he forces settlement at nuisance values. These are well-known, well-documented strategies of plaintiffs' lawyers, and they're allowed. And I'm not saying that it's not allowed or illegal, but when this happens in the thousands of lawsuits over a period of a year or two, it really becomes a little bit of a problem for anybody who would ever want to depend on fair use or use any materials that get off the internet. So be very, very careful. He's not the only plaintiff's lawyer that's doing this, but be very careful, because you can say it wasn't registered, it's only a few $100 damages, but you're defending it for 6 months and paying a lawyer tens of thousands of dollars to defend. It's very difficult, and you just end up settling for many, many thousands of dollars. I hope that made sense. That's my public service announcement.
Okay, so, and by the way, in terms of dealing with all these type of questions, I will tell you, I know there are probably a lot of folks on this call and this webinar today that when they heard your presentation, Ann, and they saw that 3-month, all went, oh crap, I've never done any of this with my work, I need to do it now. And so this clarification that it's still a value if the infringement has not occurred, I think is very helpful. And so for those of you who just went, oh crap, I didn't do it in a timely fashion, remember you could still protect your work even if you haven't registered yet, if it hasn't been infringed upon. So a couple other questions that are kind of a little bit more specific. This was very interesting. A lot of our folks that joined the call today, when they were talking about what they were doing, they were indicating they were taking previous works, previous things that they had done, and trying to put them online to make them accessible to audiences during this terrible time that we're going through. So a question, if you got permission from participants in whatever display or performance that occurred, to have that shared that evening, or that did not specifically get permission for other uses in the future, such as moving it online. I think of the old Peggy Lee case, which Robert probably knows and Ann probably knows, but when it's used in a different format, do you need to go back and get permission from the artist or those artists that you got permission perhaps for them to do the concert and have it displayed in front of an audience, but you may not have included requests to use it online in the future?
Ann, do you want to take that, or?
Well, I think you want to go ahead and talk about the licensed, in music context, the licensed situation with Facebook and YouTube and whatever may be more important. Because my general answer would be you need permission, but I think that Robert has some except exception type answer.
Well, yeah, I think you're talking about a specific license that was granted, and this is called a new technology use. And there's a whole set of cases we study, and there's 6 students online here who have studied those cases. And they would laugh when I tell the students at the beginning of class, the answer to half the questions are, it depends what it says in the contract. So I'd have to go back and read the language of that original contract. And if they were smart, they would say, all use is now known or to be discovered anytime in the future, yada, yada. If it doesn't, then you have all these cases, including a famous one with Eminem in the music industry, where they said this had to do with royalty payments, but the same idea. We're going to pay you 50% on licenses, but 15% on sales of your albums. And then came along this thing called Apple iTunes, and his lawyers went to the record company and said, hey, these are licenses, not sales of records. You owe us 50% of everything you make off of iTunes download sales. And they won. It changed the industry. And then all the contracts subsequently changed. And they said, no, you only get 15 or so % of downloads. So you have to look at what it says in the contract. If you're going to make a new use online of something that was granted in a license before that technology existed.
Great. And Robert, this one will probably be for you. I got 2 more that came early, and then we've got several folks that have added questions in the last few minutes, and we'll go through as many of those as we possibly can. But Robert, do any of the guidelines that were provided by you or Ann differ if the rights holder is a nonprofit corporation?
Well, some of them, like the Teach Act, you have to be, if you look at my slides when they come around, and I'm not an expert on the Teach Act, but I read up on it this morning, and it said that it really only applies in the case you're an instructor with a government entity like a school or a nonprofit educational institution. So with regard to 110, absolutely. With regard to 107, fair use analysis, those 4 factors, as I said, the first factor is, are you commercial or non-commercial? If we're working here for the Indiana Arts Commission, the IAC, versus Lilly, and we're doing something, I think it would be judged differently under fair use as a nonprofit activity versus a for-profit seminar. So yes, I think it can matter, and it depends on the situation. Would you agree, Ann?
Well, I think I'd probably be a little bit more conservative about it, not odd, I guess, in that what I've seen in the past is folks will go out and they will form a nonprofit corporation thinking that this will get them into the fair use box. You know, being the status of being a nonprofit corporation or forming one for the purpose will not answer the question of fair use. And so the 4 factors all come into play. And there's nothing about just being a nonprofit corporation in and of itself that establishes fair use. So.
Right, and this one will be for you because it's asking about what form someone might use. We had one of our folks, I'm guessing they do theatrical direction, asking if there was a form that needs to be filed with a video or the play or a book to protect blocking and choreography.
Well, yeah, there is the form for choreography if you're going to, file that separately. I've never actually made an application for blocking. In other words, the blocking that you're doing in a play that's written in the play, there will be, a copyright in the text of that play itself. I don't know if you could approach that in the same way. I mean, dance is notated as dance. I'd have to throw it over to Robert as far as, blocking of plays being a separate copyright. I've not ever filed anything like that.
Yeah, this is when a friend told me, you need to learn how to freeze when you don't know an answer on Zoom. I act like my screen's not working because I don't know the answer, Ann.
Yeah, I've not seen it. But I mean, blocking that is made, on the fly by every director, every play, I suppose, if you somehow fix your specific blocking into a tangible medium of expression and write it out in a way that it becomes part of the play, I would say that, you might want to file that, and then you'd have to disclaim the copyright in the play itself. It's an important point that when you file for copyright registration, anything that you do not own yourself, you have to disclaim and say you're not the owner of it. Because if you do not do that, then your entire copyright registration can be invalidated for failure to disclaim material that you do not personally own.
I would say videotape it. So this reminds me very quickly, I'll point out that in the Led Zeppelin case, the Stairway to Heaven case, which has just been up on appeal and reversed in part. So that's a whole nother, hour we could talk about a case that's, 45 years old. But what they basically said that's important in this discussion is that you can't refer to the sound recording in that case when trying to determine whether it was infringed, because the sound recording wasn't deposited. It was only the sheet music. So you can only look at what was written on the deposit copy. So when you think about today, when you're saying to get the broadest protection of something like a play with blocking included, or even a song for that matter, you could almost always do better by doing a recording of the whole song, not just sheet music with notes and lyrics, but record the whole thing in a music studio, which is then a recording as well, but it's also the song, or record a play on videotape. And then you would be capturing everything possible. Whereas if you try and write that down in Labo notation or something, it'd be very difficult to capture as broad of protection.
I guess I also need to weigh in on the topic of originality, because as I'm sitting here thinking about how, directing occurs on the fly in the process of directing a play, I think you might have a bit of trouble claiming copyright infringement based on just the blocking element on this topic of originality.
Great. Great, thanks so much. We've got a couple of questions about recorded music. So one question, we've got a singing group. They pay their licensing fees to BMI and ASCAP for their concert performances. Do these cover virtual performances that they post online?
Okay, so we can answer this pretty quickly. First of all, it's BMI and ASCAP and CSAC, and now there's Global Music Rights, GMR is a fourth. PRO, we call them, Performing Rights Organizations, are specific to venues. So they wouldn't be paid by an artist who's performing typically unless they were doing it on behalf of a venue. So it would be the club, it would be the Vogue, or it would be Indiana University to cover all their facilities and marching bands and so forth. So it's specific to the venues. So the simple answer is, if they were paying those BMI fees that you mentioned for a specific physical venue, no. The answer is no. You have to look at where are you going to be streaming. If it's online on YouTube, recorded music and put up on YouTube, YouTube actually has agreements with most of the major publishers, as I understand. And it's typically very low risk. This is not legal advice, but we talked about this in emails beforehand. It is typically very common for you to see cover songs done in bedrooms by people with their guitars, for instance. And that's usually not a problem because they're monetized by the big music publishers, and they actually like to have that music generating ad revenue and people to get streams, and then they take that money. But they do have the right to send notice and takedowns. If it's on Facebook Live concerts, Facebook, we researched that recently, and they also have engaged in licenses with most of the music publishers, direct licensing. So they've gone around ASCAP and BMI and CSAC and GMR and done direct licenses with most of, Warner and Sony and Universal and a lot of the big independent publishers. So it seems like I'm not seeing a lot of litigation out there. Where I warned you, I've seen it in the visual photography field a lot lately. I have not seen a lot of people, just as a measure, taking the temperature of the industry, publishers suing for people singing covers online, but I cannot guarantee that you're not putting yourself at risk.
Great. Well, I know we still have a few other questions that people have given that we didn't get time to get to today, but I'm sure that the Indiana Arts Commission will get this posted, and hopefully we will get you that type of information if we didn't reach your question today. I'm going to turn it back over to Bridget, who is going to close us out today.
Thanks so much, Scott. I just wanted to take a moment to thank our guest speakers, Robert and Ann, and of course, Scott, for doing a great job fielding everyone's questions. We will be sharing the recording of this webinar out tomorrow, as well as all of the resources and slide decks that Ann and Robert used. So be on the lookout for that. And please let us know too what you're facing right now. Like Lewis said at the beginning, we'd heard that intellectual property and copyright was something on everyone's mind, had a lot of questions. If there's a topic like that, please let me know so we can line up some more experts to talk to the field. I just wanted to give a few updates really quickly. The SBA relief options are now accepting applications. So if your nonprofit organization still needs to apply for payroll protection program or an EIDL loan, or you just need to know what those are and what your options are, please visit sba.gov and research those options, and also talk to your financial lender as well. They'll be able to steer you in the right direction. If you're self-employed, you are eligible for Pandemic Unemployment Assistance, PUA. Right now, you should go ahead and apply for that at unemployment.in.gov. Please know that the Department of Workforce Development is still working out how to implement that program, so your application will initially be denied. Don't worry about it. That is totally fine. It will be in a sort of holding tank until the Department of Workforce Development implements that program. The idea is that if you apply now, you should not need to reapply once the Department of Workforce Development implements the program. So go ahead and get those applications in. Next week, we'll be here again on Wednesday from 3 to 4 p.m. to talk about marketing and communications in this new space. This would be great if you are new to working in the digital space, or even if you're seasoned and you've been doing this for years. The landscape has changed a lot. Information about that webinar will be going out in the follow-up as well. Again, thank you to our experts. Thank you to all of you who joined us. We'll get through this together. Thanks, you guys. Bye-bye.
Thank you all.
Thanks, everyone.